Okay, go.
You are live.
All right, we're going to bring to order the Coastal Permit Administrator hearing, September 12th, 2024. It is 11 a.m. I'm Julia Krog. I'm your Coastal Permit Administrator today. So first off, can I have a determination of notice?
And both matters on the agenda have been properly noticed.
Thank you. Moving right into our regular calendar, case 3A, Boundary Line Adjustment 2024-0012. Staff planner is Dirk Larson. May I have your presentation, please?
Sure. Let's see. This is a coastal boundary line adjustment. Both are both are zoned timber preserve and classified forest land under the general plan. This involves a lot that doesn't currently have its own parcel number. It was formed by a CC in 2007. And both are actually considered legal non-conforming as they don't currently conform to the minimum acreage size under this district. This proposal will not change that status. The project site area is mapped by a high fire hazard area, and the South Coast Fire Protection is a responsible fire agency. Neither lot is located within a highly scenic or special plan area. The project was referred out to all responsible agencies on April 30th. The only agency to provide any comments was the Coastal Commission. They raised some concerns regarding the two existing residences and whether they conform to the codes and density requirements for the district. They also questioned the potential site area identified on Lot 1 on the tentative map included with the application. The project does have two existing residences that were in place prior to the enactment of the Division II Coastal Zoning Code in '91. One was built in the 1950s, the other in the 1970s. This project proposed to locate both residences and appurtenant structures on what will become Lot 1, while proposed Lot 2 will be vacant. Lot 1 will be at max density at that time, while any future proposed development on Lot 2 will require a coastal development permit and additional studies to determine any potential impacts proposed development may have on sensitive habitats or resources in the area. Staff also addressed the question raised by the Coastal Commission regarding the potential home site illustrated on the tentative map. Staff required the applicant to demonstrate that Lot 1, created via Certificate of Compliance in '07, had the potential to be developed in its current configuration as required by Mendocino County boundary line adjustment procedures. No lot, and in short, no lot created via CC, land patent, or other instrument shall be recognized as separate lot unless it can be demonstrated the development could occur in its current form or configuration. The applicant satisfied this requirement and demonstrated that in its current form there was potential for residential development. There are some sensitive habitats near the project area. However, no development is associated with this project, and any future development will require applying for a coastal development permit on what will become Lot 2, which may include further analysis and studies be done to determine potential impacts. This project was reviewed by staff and found to be consistent with the goals and policies of the coastal element. The project is categorically exempt under Class 5A pursuant to the California Code of Regulations, Section 15305, considered a minor alteration of land. Therefore, no further environmental review is required with this project. It was also reviewed by the Subdivision Committee on this date, September 12, 2024, who recommended the Coastal Permit Administrator approve this project as no conflicts with the Division of Land Regulations were identified. With that, staff is recommending the Coastal Permit Administrator approve this project subject to the findings and conditions of approval discussed and included in the staff report.
Great.
That's it.
Thank you. So it sounds like the Coastal Commission comments, you've addressed those
Yeah,
fully.
they were satisfied.
And it looked like the residences are pre-Coastal Act, actually.
Yeah, pretty much.
Excellent.
Yes.
Okay.
Yeah.
So now I'm going to turn to see if we have the applicant or agent on the line. And I see we've brought over Jim. Please proceed with your comments and state your name for the record.
Well, I'm Jim Ronco, and I have no comment beyond the excellent staff report prepared by Dirk. And we look forward to having this project approved and so we can move forward.
Perfect. Thank you, Jim. Okay, so then I'll go ahead and open the public hearing and see if we have any members of the public, either in the room or on Zoom, who wish to speak on this item. And if you're on Zoom, please just use the raise hand feature so we can add you to the meeting. I'm not seeing hands raised on there. Any comments in the room? Seeing none. Okay, I'll bring it back to the Coastal Permit Administrator. So thank you, staff, again for your detailed review of the staff report and your recommendations. So I will approve this boundary line adjustment subject to the findings and conditions as contained within the staff report with no modifications.
So,
Okay, thank you. Okay, moving on to our second item on the
Oh,
agenda.
he's raising his hand, Jim.
Oh, Jim. Yes, go ahead, Jim.
Thank you.
Thank you. Have a good rest of your day.
Okay.
Okay, and moving on to case 3B on our agenda, which is Coastal Development Permit 2020-0037, and Staff Planner Shelby Miller. May I have your presentation?
Sure. Hello. Thank you, CPA. This is Project Planner Shelby Miller. The project requests a standard coastal development permit to gravel an existing driveway approach, grade and gravel, a driveway extension, construct a single-family residence, 2,663 square feet, an attached covered breezeway, a 742 square foot garage, a 1,659 square foot barn, fencing, converting a test well to a production well, installing a pump house, water storage tanks, a septic system, a propane tank, and undergrounding utilities. The barn is going to consist of storage and livestock. The project is located in the coastal zone, roughly 5 miles south of Elk, lying on the west side of State Route 1, and located at 12,200 South Highway 1 in Elk. As detailed in the staff report, the project request complies with the applicable general plan and zoning designation of rangelands. Considering the project is situated on rangelands, the landowner provided a pasture lease agreement that notes that the landowner would lease livestock for a minimum of 2 years. The application included a geotechnical investigation and a biological survey in which all mitigation measures have been included as conditions of approval. The biological survey stated that there is a potential habitat for the Pointerina mountain beavers west of the bluff edge. However, no ESHAs were identified during the site investigations. The proposed development would be situated greater than 100 feet from the bluff edge. The project was referred out on April 22nd, 2021, and again on April 2nd. Oh, did I say April 22? Yeah. April 2nd, 2024, following a change in the project scope. The California Department of Fish and Wildlife recommended several items, including livestock and their byproducts should be kept out of potential environmentally sensitive habitat areas, and recommends livestock be kept in a fenced area to prevent impacts on potential ESHA, or environmentally sensitive habitat areas. A deed restriction west of bluff edge to reduce the likelihood of potential impacts to the ESHA. All landscaping that would screen development should be comprised of appropriate locally native trees and shrubs. The landowners are encouraged to plant locally native species throughout the property to sustain or increase the biodiversity to benefit other native plant and wildlife species. The California Coastal Commission recommended a condition requiring that the primary use of the site is agriculture and that the residence is incidental to this use. The Coastal Commission also concurred with the Department of Fish and Wildlife recommendations and recommended that the deed restriction includes a condition prohibiting future armoring of the bluff. All relevant recommendations were incorporated as conditions of approval. One public comment was received on August 10th, 2024 from the adjacent neighbor requesting additional information regarding the regulations and project description. County staff replied to the neighbor on August 12th, 2024 and answered all questions. No other comments were received. And then staff reviewed the staff report this morning and added condition of approval number 36, which states this entitlement does not become effective or operative and no work shall be commenced under this entitlement until the California Department of Fish and Wildlife filing fee is required or authorized by section 711.4 of the Fish and Game Code are submitted to the Mendocino County Planning and Building Services. Said fee of $2,966.75 or current fee shall be made payable to the Mendocino County Clerk and submitted to the Department of Planning and Building Services within 5 days of the end of any appeal period. Any waiver of the fee shall be on a form issued by the Department of Fish and Wildlife upon their finding that the project has no effect on the environment. If the project is appealed, the payment will be held by the Department of Planning and Building Services until the appeal is decided. Depending on the outcome of the appeal, the payment will either be filed with the county clerk if the project is approved, or returned to the payer if the project is denied. Failure to pay this fee by the specified deadline shall result in the entitlement becoming null and void. The applicant has a sole responsibility to ensure timely compliance with this condition, and that is the condition of number 36. And then a mitigated negative declaration was proposed for this project to comply with the California Environmental Quality Act. And staff recommends approval of this coastal development permit. Thank you.
Thank you, okay. I have one question for you before we go to the applicant.
Sure.
On condition 9 in part E, when you were mentioning about the commission wanting to require essentially the agricultural area of the property to be identified in a deed restriction, I want to just confirm that that's the area identified on the site plan as the livestock area.
Correct.
Correct? Okay,
Yep.
good. Just making sure that we have that clear. And I will likely want to add that language to this condition so it's clear when a
Okay.
deed restriction's filed, what is actually highlighted on there. So,
Sure.
okay, thank you. That was my only question. And so now I'll look to the applicants. Please just state your name for the record and any comments you may have or any issues.
My name is Tom Parsons, applicant. I don't have any issues. I just I hadn't heard number 36 before, so I just need to know. I mean, I guess get it presented to us so that we know.
Yeah, explain
Where
it
to-
a little further. My name's Kelly Parsons.
Sure. So that condition, it's actually required under the California Environmental Quality Act. So when there is preparation of an environmental document, such as a mitigated negative declaration in the case of your project, or a negative declaration where there's no mitigation measures, there's a required filing fee that goes to the state, and it's for them to essentially perform, it's for furtherment of protection of fish and wildlife and habitat. So that is the fee that we just to collect from you, and then that actually gets paid over to the county clerk along with the filing of a notice that says that we've approved this project and made findings that the project's adequately mitigated. So, so that fee would be due after, if your project is approved today, then it's due within essentially 5 days to facilitate that filing.
We're here so we could pay it today.
Yes, so you could always write the check today, and then Shelby can facilitate that filing. So, yeah. So that's what the fee covers.
Okay.
Yeah. Unfortunately, we're the intermediary there. There is also a pathway where you can request a no effect determination from the state. However, I will just note that those are very seldomly granted from what I have seen.
Yeah.
So, yeah.
We've gone this far, we don't need to.
Yeah, we know.
Okay. So any other questions on that or any other comments?
No, I understand all of it. We've read it. Thank you.
Of course.
Yeah.
Okay. Great. Well, thank you for your comments. So then I will open the public hearing. However, seeing no members of the public on Zoom or in the room, I'm going to close the public hearing and bring it back to the Coastal Permit Administrator. So I will want to add that condition 36 that shall be read into the record. And then I do want to amend condition 9E to just have, it says, development proposed within the agricultural area of the parcel, and I just want to say identified as the livestock area on the site plan.
What page are you on?
On CPA 11, oh, you'll go back this way now. And part E here. So I'd just like to add, so where it says development proposed within the agricultural area of the parcel identified as livestock area on the site plan is limited to coastal agricultural use types, and keep the remainder of that condition. I just want to make it clear what is the area that you're identifying as the
Yeah.
agricultural area, so
Eliminate
it's
any
not,
vagary. Right.
exactly, so it's
Right.
not open to interpretation in the future.
Right.
So.
Right.
And that'll make it clear also for preparing that deed restriction
Right.
language, so you know as well the area that's been mapped for
Right.
that. So, okay, great. So with that, I will approve the project, subject to the findings in the staff report and the conditions as modified, including adopting the mitigated negative declaration and the mitigation monitoring and reporting program associated with it. So with that, your project is approved.
Thank you.
Yes.
Thank you.
And so you will
Yeah, of
have
course.
now 2 appeal periods that are associated with this. I don't know if Shelby's explained that to you
Yeah.
previously as well.
Can I just ask for clarification? I did not understand. Is it the public can appeal now from 10 days starting tomorrow?
Correct.
10 days,
10
not
calendar
business days,
Yes.
calendar days.
Yes.
And then, if there is an appeal from the public, the CDP has another 10
No.
working days, or they have 10 working days?
Great question. So, so there's 2 different appeal periods. So
Right.
there's the first 10 calendar days that you were describing, that's with our local board of supervisors, where
Right.
either if you were dissatisfied with the decision or a member of the public was dissatisfied with the decision, they could appeal it to our local board of supervisors.
Okay,
That would sort of stay the approval until that appeal is decided upon.
okay,
If no appeal is filed, then there is a secondary appeal period because of where you're located within the coastal zone that's with the
Yeah.
State Coastal Commission.
okay,
And that's a 10 business day.
10 business day.
Appeal period.
okay.
So roughly what I've worked it out to, it works out to about 30 days after today's hearing is when you will, all appeal periods will have concluded and you would have an effective permit
Yeah.
if no appeal is filed.
I was figuring it out to be like Monday, October 7th. I was
Yeah.
thinking that was the day. And
Well,
then what
you have to
happens
account
after
for
that?
you have to account for the mail, and then
Right.
also the Coastal Commission
True,
has 3
okay,
days
okay,
before they have to
okay.
open the appeal
Add a
period.
little bit
So,
more. Okay, okay.
Yeah.
And then what happens after that?
so once you have a final effective permit, then we prepare it's an actual permit form that you're going to receive in the mail from us, which will
Okay.
have your effective date and your expiration date, and have
Perfect.
all of your conditions of approval attached to it.
Okay,
And then you can begin, preparing for any building permit submittals and
Right,
complying
the
with your
deed
conditions of approval.
conditions and that
Exactly.
okay.
So do
Okay.
do the deed restrictions have to be in, I'm assuming we hire a title company or somebody to do, a title company to do that? And do those have to be done before a building permit is issued? I mean,
Yes.
I'm assuming we could start on them after the appeal period right away.
Yes, you can.
And can you start on the building permit process right away as well?
You certainly can. You would just need the deed restriction recorded and meeting any other prior to issuance of a building permit conditions within the adopted conditions.
Okay,
And then, let's say, so that the well can get turned in from a test well to a complete,
a production well.
Yes.
and the septic system can be
Yes.
all those things can happen after the deed restrictions are in place.
Correct. And we have a template for the deed restriction, and so you can easily work with, oftentimes folks will work with an attorney, or they may reach out to a title company to assist them to prepare that. And then it does have to come back to us and go through review with our county counsel's office before it's executed.
But
Okay.
that will all be laid out and very clear to us when you send us the,
Yes.
Okay.
If
Oh,
we can just hand over to the title company.
Yes,
they'll know what-
yeah.
okay.
Yeah.
Great.
And then it'll come back through us, we'll route it through our county counsel's office, and then ultimately, you will sign the document once it's been approved in front of a notary and provide that notarized copy to us, and then I will sign with a notary, and then we will record that on your behalf.
Great.
Yeah.
Okay. That eliminates that confusion.
Yeah.
Thank you.
Of course.
Okay, great, so let me keep going with our agenda. Any matters from staff today? No matters from staff, excellent. Any matters from the public? No matters
You
from the
addressed
public.
it.
Sorry, I looked to you, you're the only members of the public here today. So I'm gonna go ahead and adjourn the meeting at 11:20 this morning.
Nice.
Thank you.
Well, yes, congratulations.